Welcome to Notable Approvals. I am attorney Amanda Shaffer. Today I have a really exciting case to talk about, a type of case I call marathon cases because of how long it took. And I just finished virtual immigration court, so always excited to talk about my cases right after I just won. So before I get to the case today, a few quick reminders. First, don't forget to like us and follow us on Facebook, Instagram, YouTube, wherever you are watching or wherever you see us on social media. If you find what you see or hear today helpful, or you think you know somebody who will, please go ahead and click that share button so that other people can find this information as well. And I will not be answering questions about specifically. Hi, Nikki. Thank you for watching. I was about to just address, you have a question, I see. I was going to just say, I'm not here to answer questions specifically about anything other than this case, but if you have a question about your own case, then please feel free to contact me privately after, and I'll be happy to help. My contact information on Facebook and YouTube will be scrolling across the bottom of your screen. And on Instagram, you can go to our bio page and all the contact information will be there. So let's get to the case today. So today's case is about a client who is a native and citizen of Ivory Coast. He first entered the U.S. back in 2000 with a B1. You're very welcome, Nikki. And again, if you do have any questions at any time, if it's not about this case, please contact me afterwards and I'll be happy to help. So this client entered the U.S. in 2000 with a B1 visitor visa. However, the passport and visa he entered with, it was a U.S. visa in a Mali passport from the country of Mali. And all the information was his, even the picture, except his name was spelled differently. And that actually has to do more with a difference between the spellings of his first name in the two countries. Anyways, he got the visa through an agency that said he was going to a dance group. None of that was true. He's not from Mali. He's not a native or citizen. He's never even been to the country. But the reason that he did that was because at the time, the Ivory Coast was going through a brutal civil war, and a lot of people were fleeing the country. In fact, he couldn't even apply for a visa in the Ivory Coast at the time because the U.S. embassies and consulate was closed. So he came to the U.S., and he eventually married a U.S. citizen. I think that was in 2004. And the marriage didn't work out. She did file for a marriage petition for him so he can get a green card, but the marriage didn't work out. They ended up getting divorced in 2008. In 2014, he married his second wife, also a U.S. citizen. She then filed for him also. She filed for a marriage petition and for his green card. And when you're able to file your marriage, your alien relative petition, it's really called your I-130 petition, and your green card application at the same time. And that's when the person filing for you is an immediate relative, like a U.S. citizen spouse or a U.S. citizen parent when you're under 21. I'm not getting into all of those categories. Point is, not a lot of people can do it, but in this situation, he could. So when you do that, you get a employment authorization document. You can also request an advanced parole travel document, which would allow you to leave the U.S. and re-enter the country while your green card application is pending. If you leave the country while your green card application is pending without your advanced parole travel document, you're abandoning your application. So what ended up happening was my client at the time, I don't even know if he had a lawyer. We weren't his lawyer when he applied. This was back in, I want to say 2014, 2015, after he got married. He got the advanced parole travel document as well as the work permit, and he was a truck driver at the time. And he was driving his truck in Maine near the Canada border, and he was supposed to get off at the last exit in Maine before you hit Canada. Now, if he entered in a visa in his own name, but overstayed, which is the situation a lot of our clients are in, and had an advanced pro travel document that was valid, like he did, what happened in 2015 would never have became a problem. But 1 second, Joey, hey, sorry, my dog likes to drink a lot of water. It's way too much water than he needs. So he was driving at the border. He passes the exit, so he ends up entering Canada. He immediately realizes and turns around and tries to re-enter the US, and he gets stopped at the border by Customs and Border Patrol. So he gives them, his travel document, says, I can re-enter. They look him up and they say, well, hold on. You committed fraud when you initially entered the US. You're not, who's this person? You're not from Mali. You says you're from the Ivory Coast. So this is actually something we don't see as much anymore because it's gotten harder with technology, but especially people who came to the US years ago and who used somebody else's passport or visa to enter the US. When you go to it is considered, there's different types of waivers that you might need. You hear a lot about people who just cross the border or enter without inspection or admission. When you enter with somebody's passport that's not a US passport, somebody's visa with a valid visa, when you enter someone else's valid visa or a fake visa, and you present it at the border, whether it's a land, sea, or plane, and they admit you into the US, you're considered admitted. You're inspected and admitted. They've literally inspected and admitted you, which is different than if you just cross the border and there's no inspection and admission. Both cases, you have what's called an inadmissibility. Both cases, you need a waiver. The only question really becomes down the line on how you end up getting a green card or what the process that you have to go through. And that depends on many factors outside of the scope of what we're talking about today. But just to give you an idea of what we're talking about here. So when a client does come to us and we find out that they entered the US lawfully in the terms of they submitted a document to a US officer and they were admitted into the country, but the document was fake because it wasn't theirs, or the information on it was fake, then we know they're going to need a fraud or misrepresentation waiver. This is called a 601 waiver, or in removal proceedings, a 212H waiver. And we would tell them, you're not eligible for a travel document. And as I mentioned earlier, this client applied for a travel document with USCIS and was granted the travel document and had it with him when he accidentally left the country. But guess what? It doesn't matter, unfortunately. What doesn't matter is that USCIS, they granted it because they could have denied it, but they didn't. They probably should have denied it because he technically wasn't eligible. They may not have realized at the time that he entered fraudulently because that determination hadn't been made. So when we know that's an issue, we tell clients don't even bother applying, because even if they grant it and you get the document, if you leave the country, they might not let you back in, or they're going to do what they did with this client, which is put him in deportation proceedings. He was very lucky that he actually didn't get put into detention. I think, they put him in, they detained him temporarily while they processed him, but they didn't detain him. Nobody had to bond him out or anything. They released him. He got to continue his truck route and make his deliveries and continue on with his life. After that happened was when he came to us. And then we had to go to court, and the marriage petition by his wife had already been filed, I think even approved. But at that point, we had to file a waiver. So like I said, the waiver that we had to file is called the 601 waiver. And when you're in immigration court proceedings, it's called a 212H waiver. It's the same form, but essentially you have to prove that there is an extreme hardship to a qualifying relative. And for that type of waiver, a qualifying relative would be a U.S. citizen spouse or parent. It also could be a permanent resident spouse or parent. Oh, yeah, fraud and representation. There's two. Yes, I'm right about that. So if you had a U.S. citizen child, although if that child would suffer hardship, which we did talk about as children, the U.S. citizen children were not considered qualifying relatives. So if he didn't have a qualifying relative, he wouldn't even be eligible for the waiver in the first place. So I think our first hearing with him was like 2016, I want to say, and it got put on for the individual or the merits hearing, and we had to file the waiver, and we had to file a lot of evidence with the waiver, and then we had the trial. And that trial happened back in 2019, right before, not a few months before COVID really started. So what happened was we applied for the waiver, obviously. And what the waiver was based on was his wife had medical issues, and she was also financially dependent on him. And if you've ever watched any of my other notable approvals where I've talked about any type of waivers or cancellation of removal, which is a little different, it's actually harder to get cancellation of removal. The burden, the bar is higher than the 601 waiver. And if he didn't enter with inspection and admission, he may have had to have done cancellation of removal. So it's ideal to be able to prove that you entered with inspection. In some cases, a difference with cancellation of removal is you have additional relatives that may qualify to make you eligible. But again, that's for a different show. So we have to still show that his wife or his qualifying relative will suffer an extreme hardship if he stays in the U.S. or if he leaves the U.S. and she goes back with him to the Ivory Coast. So what we did is before I get to what we showed, I'll tell you another problem in this case that made it even harder. It's never easy to show an extreme hardship. But in this case, our client, he lives in Brooklyn and has lived in Brooklyn this whole time. And his wife had lived in Brooklyn, but then moved up to Binghamton. If you don't know where Binghamton is in relation to Brooklyn, it's about, it's past Albany, let me say 4 or 5 hours. You can correct me if you're watching this. You can correct me if I'm wrong. About 4 or 5 hour drive to Binghamton. So, that's a big difference. Also, the other obstacles we had, my client has 5 biological children in the U.S. from the same woman, but all before he met his current wife. And he was never married to that woman. Obviously, he was married before. His wife had been married before. So these are all factors. He had 4 other kids back in the Ivory Coast. And he also had 4 stepkids. Is that 11? I may have mixed up the numbers. I know he has 4 stepkids with his current wife. And they all lived up in Binghamton. So not only did we have to do the usual showing of the extreme hardship, we had to explain to this court, well, how can his wife need him here in the U.S. if they don't even live together full time? And I've also talked about in other notable approvals cases where the husband and the wife, we were able to get their marriage petition approved even though they didn't live together. And I've always stressed that each case is different and you have to look at the facts and the circumstances of the case. And in this situation, it did make sense, and I'll explain why in a second, but it makes it that much harder. So essentially, the wife had lost her job in Brooklyn and she tried to find a new job, but she couldn't. And considering how many children she had and how expensive it is to live here, when she got married to my client, they weren't going to really be able to stay in that apartment with all her children. So she ended up moving up to Binghamton, where her sister and her mother lived, who can help take care of the children, where it was cheaper, a lot cheaper to live, and where she was able to get a job. And she did get a job up there. She's a nursing home attendant. So what my client, who now no longer drove a truck, he actually drives Uber. And in Binghamton, although I believe they have Ubers, I've been to Binghamton, but a really long time ago, back before Uber existed. But I do believe they have them. They do not have nearly as much need for them, and you don't get paid nearly as much as you do if you drive in the city. So it really wasn't going to be possible for him to live up there full time. And we had to show that he did visit her basically every weekend or every other weekend. He financially supported her. And that was one of the big things. Yes, she worked full time. At some point during the course of the proceedings, she lost her full-time job and had to work part-time, but she really depended on his income to support her children. And nursing home attendants really, they don't make that much. It goes a lot further, that income upstate, but still, she really needed him for that purpose. And we also had to explain that, you know, this wasn't just a financial relationship, that this situation they were in was not what they were planning for their future. The whole plan was that they testified to, and we submitted evidence of, that once my client gets his green card, they are going to plan to move down south where it's cheaper and be much easier for him to get an actual job. Because remember, when you're waiting for your green card, you may have permission to work, but you have to renew your work permit every year, and it is a lot harder to get a stable job. And there sometimes you don't get your renewal in time, and you might lose your job. And having that many children to support, it's not a situation where that you're going to be in a good situation if that happened. So he had to make sure he kept his job. So the other part of it was his wife's medical issues, and she had several. She had diabetes, she had depression, anxiety, which she was taking medication for and was in therapy for. Part of it due to understandably the stress of what her husband was going through at the time, but it was above and beyond that. She also had an iron, I'm going to pronounce this wrong, anemia, iron deficiency. That I think I spelled it wrong, and I'm not, on top of that mispronouncing it, so I apologize. And a vitamin D deficiency, which for those things she was taking medication for as well. In addition to the medical issues, she had her children. She had 4 kids that lived with her. They were all hers. Not all different fathers, who only really one of them had involvement with the children. So again, not getting child support made it even a bigger reason why she needed her husband's income to support herself and her children. And for about half of the proceedings, she actually was the legal guardian of her nephew, because of issues at home or something. I honestly, when we actually did the hearing, today was the decision. We did the hearing in 2019, so it's in June 2019. So it's been a little while. In addition to that, she had a visitation order for her youngest daughter with the father, and there was a geographical limitations clause on there. So she had to be in a certain area so that he can see his daughter, which she had a right to. And then on top of that, she had her son, one of her sons, who had decided as a young teen to go joyriding, got caught by the police, went to juvenile detention, was released, and had a probation order which prohibited his ability to relocate. So I'm kind of getting into why she couldn't leave the U.S. also, but essentially what I'm trying to say is she needed his support financially because of all these things that were going on in her life, but she also needed to be in a place where she was close to her mother, who was able to help her with the children, whereas my client was out working all day long, as was she. So that was the reason that she needed to stay in the U.S. and that she needed him to stay with her, or I should say the reason that she needed him to stay in the U.S. with her. That was part 1. Part 2 we had to prove was that she couldn't leave the US with him, with my client and her family, and go live in the Ivory Coast, where he's from. So the medical problems were, of course, the first thing you point to, that she's not going to get the same treatment that she can here over there, which is very true. Mental health issues aren't as well understood, and just the healthcare, the U.S. healthcare could be better in an ideal circumstance, but it's still much better than it is over there in Africa. And she doesn't speak French. My client does speak English. She doesn't speak French, and she's never been to the Ivory Coast. And not everyone in the Ivory Coast speaks French, speaks English. In fact, most of the people don't. So that would have been a problem. Her kids don't speak French either. Again, one of the children, her youngest, had a visitation order. So she would have needed to go to court, either get consent from the father, who already had said no, or get a new court order to allow her to relocate, which was going to be difficult because the Ivory Coast had been going through a civil war for years. And although the civil war was I think it was over at the time we had the hearing, I do a lot of asylum cases from Ivory Coast. It's still not great over there. And if I'm a parent, if I'm the non-custodial parent, I'm going to object to that, not because the country's not great and because I'm not going to see my kid anymore. So we showed that. And then, like I said, her oldest son being released from juvenile detention, he wasn't even allowed to get a passport. So he wouldn't have had anyone to live with, and he was released to her. So even if she had someone else for him to live with, and that was it, and that situation would have been okay, which arguably would not have. He needed at least his mother. She would have been in violation of a court order. And then, of course, finally we talked about her employment and how she couldn't have gotten equivalent employment over there in the Ivory Coast. So that was an extremely extreme hardship case to prove. Although there were so many factors, it was hard because we had to get all of the evidence. There was hours of testimony. It was really emotional testimony. I remember we had to stop at one point because his wife was understandably having a hard time with the government's questions, because they can be a little rough sometimes. But that's not the end of the eligibility part of the waiver. You also have to show good moral character, which that was actually probably the easiest part here. My client's never been arrested anywhere in the world. When he entered the U.S., he was a lot younger. Like I said, it was 2000. He was like 25 years old. And there is reason for using a fraudulent visa to enter was understandable. He did so because there was a civil war going on in his country, and he was not alone in doing what he did. So although nobody should violate the immigration laws, or any laws for that matter, when people apply for asylum, that's something that's the reason why you don't need a fraud waiver for asylum, because you're fleeing your country, which is what he did. He didn't apply for asylum, and that was asked about. And as with a lot of people, they don't know about it, or when they find out about it, it's past that 1 year mark, which is a deadline, and they just never apply, or they don't know how to apply, or don't know what to do. So he just never applied. And then we also provided proof of his employment all these years. He's paid all of his taxes. And like I said, he had, I think I said 5 U.S. citizen children who lived in the U.S. with the mother. We provided evidence. We actually got a letter from her, because they are on good terms. And I said, he pays me child support. He's always on time. He always pays. He's very involved with his children's life, which they are U.S. citizens. But again, the qualifying relative for this type of waiver does not include U.S. citizen children, but it's definitely a positive factor that weighs in his favor, that he's involved in their lives and pays child support. So we showed that. And then, of course, the last part of the eligibility requirement is that even if we prove all the things I just said, that my client, that there's an extreme hardship to his qualifying relative, his U.S. citizen wife, that he has good moral character, they still can deny it. The judge, or if USCIS can adjudicate this type of waiver, but because he was in court, it was up to the judge. The immigration judge has to exercise discretion favorably. And what that means is the judge has to want to grant it. The judge could say, you know what, yes to all these factors, but you still violated the law, and I don't want to grant it. And would we have appealed that decision? Of course. Does that happen? Of course. So that we still have to show the positives outweigh the negatives, and that's kind of a wild card factor. This judge, I've had a bunch of cases with now. I think he's very fair. I thought that this was obviously a very good decision, but that based on the equities in this case, I thought it made sense. So after proving all of that, at the end of all of that, remember when my client first applied for everything, except for the waiver, it was back in 2015. And by everything, I mean the marriage petition, which had been approved at this point, the green card application, and that includes the affidavit of support with all the financial documents. So the Department of Homeland Security decided at the hearing they wanted updated financial documents more than we had given, because we had given and then the case got rescheduled, not because of our own fault. So, and we also need an updated medical record or medical report. So the judge gave us a short adjournment of a few months back in the summer of 2019. This is the part that really was frustrating and turned what was already like a marathon long case into an ultra marathon. We went back that 3 months later. We were there. The government attorney was there. The judge was not there. I don't know why. To this day, I don't know why. But for whether he was sick or what happened, the judge didn't show up that day. So although we had everything that was asked for and it already appeared the case was going to get granted, it was like the end of the summer of 2019 at this point, we had to get the case rescheduled because the judge wasn't there. And even more frustrating is we had to walk out of that hearing not knowing when the next hearing would be, because normally when the judge is there, they look at their calendar, they confirm the date with you and the trial attorney, and then you come back and you go from there. So when we finally get the hearing notice, it was scheduled, I want to say 2020, I think it was in 2021. Maybe it was this date. Honestly, this is the least important part because COVID hit. And when COVID hit, my client was like, I think he had, it was scheduled during COVID. It was scheduled in 2020. That's what it was. COVID hits, and my client was like, can we do anything about this? The courts were closed. Can we file anything to get the date moved up? We got a new date, and that was today's date. And I was like, well, we can try filing a motion to advance. And that just means that we're saying to the court, like, look, this is just scheduled for a decision. It should take a half hour at most. My client's been waiting since now. He was supposed to only wait a few months. The reason it got rescheduled was the judge, you have to be very nice when you write this in your brief, but your honor did not appear that day in court. So unfortunately we had to reschedule it. So, please reschedule it. It's, this man wants to move on with his life essentially. And the judge actually, I think he called me. He gave a written decision too and apologized. Said, I'm really sorry. I don't have any other dates. I can't advance it. And I was like, we can just issue a written decision, but because they have to open the medical report on the record, and DHS, I believe DHS, the trial attorney, had stated on the record they weren't going to object, but they may have reserved their decision and to not object until they saw that he was medically eligible. So I was like, okay. So we filed the motion. It got denied with an apology for what it's worth. So as today drew closer and Omicron's been, ravaging the country, The immigration courts actually did close again, but for unrepresented parties. So, but I was still hearing about cases being postponed, and things were kind of all over the map, and then you don't know, will the judge have the file, will the trial attorney have the file? So it was a lot of stress going into it because this client has been waiting for so long for it to be over. Thankfully, it took a little longer than I thought because the judge, we had the issue this week. How do we get the new medical exam? So we submitted one in 2019, but it's already been 2 years and they expire. And the COVID vaccine now is a requirement. So my client did get a new medical. He brings it in and I was like, okay, we'll overnight it. But then I was told that there's no way the judge will get it in time because they're so backed up in the mailroom. So I had to find out the legal assistant who that was. I called or emailed the legal assistant, and she said, you can, because as far as I knew, you weren't allowed to go in person, because normally this hearing is in person. We just bring it in and hand it in, but we couldn't do that. So I didn't know if anyone was allowed in the building. So they called and they said, you could send someone to drop it off. So my client came back the next day, picked it up, brought it there, dropped it off. We got a call from the legal assistant confirming she received it. The judge wasn't even at the court, so she had to scan it, send it to him. She had to get permission to open it because normally only the judge is allowed to open it. But it got there, and DHS got a copy, so everything went well. It was some connection issues with my client getting on because he was calling from a car, which, please, if you are calling into immigration court or videoing into immigration court or any court for that matter during these virtual appearances, make sure you are connected to good, strong Wi-Fi. Check your connection beforehand. Don't sit in a car or in an area that you're not sure of. You need a private place that's quiet and that has good Wi-Fi. Luckily, the judge, because it kept breaking up his video, said just call in. It worked. We were able to finish up. I got a little nervous when the government attorney was like, I'd like to ask a few questions to clarify. And, I'm just like, all right, we're not going through all of this again, are we? Luckily not. And then at the end, instead of objecting or reserving appeal, he deferred to the judge, which meant they waived appeal, and the judge then granted the case to my relief and my client's relief. In all honesty, I felt over all these years, this case was always going to get granted. It was just so frustrating how long it took. But finally, my client can move on with his life, and so can his wife and kids. And the judge was so nice to not even wait for me to receive it in the mail. He actually emailed me the order already, approving the waiver and approving the adjustment of status application, which is the green card application. And then that means my client should receive his green card, hopefully within the next couple of weeks, but very, very soon. And since he is married to a U.S. citizen spouse, and they're planning to permanently be residing together shortly, he will then be eligible for his naturalization in 3 years. Otherwise, he will be eligible in 5 years. So, that took a long time to explain all that, but that's what happens in these marathon cases. I am exhausted. I still have lots of more work to do on a Friday, but it is a happy Friday nonetheless. That's all today for notable approvals. Make sure to like us and follow us on YouTube, Facebook, Instagram, wherever you're watching this, so you don't miss any more of our notable approvals. And check out all of our other informative content and other cases we talk about, because we have lots of interesting cases. I always try, in a case like this, I want to talk about right away, not just because it's fresh in my memory, because of I'm actually really excited and happy for the client. I am tired. It's been a long week, and this case has exhausted me because of just dealing with the stress of waiting. But if anything, I'm not as energetic as I've been after court, talking sometimes about these cases. But I think I have a much more sense of calm and relief. And also make sure if you find this video helpful or know someone who will be, share it. And if you have any questions about your own case, including our friend Nikki who commented earlier, our contact information has been scrolling across the bottom of the screen on YouTube and Facebook, and on Instagram. You can find us. You can send me a direct message or find our contact information in the bio. That is all today. I'll be back as soon as possible with another. I have actually a list of cases I've been wanting to talk about, just haven't had the time because we've been winning left and right, which is a good thing, but we've also been really busy, which is another good thing. So everything's all good here at the Shapiro Law Firm, or virtually from the Shapiro Law Firm. We hope it's all going well with you. Stay safe and warm with this bomb cyclone apparently coming this weekend. Thank you all for watching. We'll see you next time.